Hello, everyone, and welcome to Pop de Jure, where pop culture and law collide. I'm your host, attorney Chinwé Foster, and this video has been sponsored by the Foster Law Firm. All images and information in this video are for educational purposes only. On our first episode, we spoke about Atlanta rappers Young Thug and Gunna still being in jail for violation of the Georgia RICO statute. And a lot of you had questions about why they even still in jail. They're still in jail because they don't have bonds. One of the reasons that prosecutors claim that Young Thug and Gunna should not receive a bond is because they're a danger to the community. Prosecutors claim that gangs such as Young Slime Life, YSL, are the cause of 75% to 80% of the crime rate in Atlanta. So they claim that if they're able to bring down these gangs, that it would also reduce the crime rate in Atlanta. During Young Thug's bond hearing, the judge here in this case, Judge Glanville, specifically stated that the reason that he was denying Young Thug's bail is because he was a danger to the community. The judge, in fact, quoted statements provided by the prosecutor by other gang members that stated that Young Thug was the leader of YSL, that he was dangerous, and that if they crossed him, he would kill them and their families. Young Thug was denied bail, and he will continue to sit in jail as he awaits trial. Despite what many prosecutors may think, the purpose of bond is supposed to ensure the court that you will come back to court. Bond is not supposed to be punitive. Bond is supposed to be a financial guarantee to the court that you will come back to court. In Georgia, when you're first arrested, you typically will go before a judge within 48 hours, and that's typically a magistrate judge. This appearance is called your first appearance. At the first appearance, the magistrate judge will typically set a bond for you if you're eligible for bond. Now, there are some charges in Georgia that the magistrate judge cannot set a bond for. For example, charges like murder, aggravated assault, aggravated sodomy, the 7 deadlies. Magistrate judges cannot set bonds for these types of charges. In that instance, you have to go before a superior court judge for that superior court judge to set a bond if you're eligible for a bond. If you're denied bond at first appearance, your attorney can file a motion for bond so the superior court judge can hear your argument for bond. If you're denied bond at any stage of the proceedings, your attorney could also file a motion to reconsider bond, especially if your circumstances have changed. How is bond determined? I hear all the time people saying, well, so-and-so didn't get a bond, or how come Young Thug didn't get a bond and this other person got a bond? 2 people charged with the same things may not get the same bond, or one person may get bond and the other person may not. That's because the courts are supposed to consider certain factors when considering granting bond. These factors are called the Ayala factors. The Ayala factors are factors that the court is supposed to consider when granting a bond. The Ayala factors stem from a case, Ayala v. State, where the Georgia Appellate Court spelled out factors that judges are supposed to consider when granting a bond. The Ayala factors are whether the defendant has sufficient ties to the community that makes them not a flight risk, whether the defendant is a danger or threat to the community, whether the defendant is at risk to commit another crime if released on bond, whether the defendant is at risk of intimidating witnesses if released on bond. Despite what a person is charged with or how horrible the allegations are, the judges are only supposed to consider these Ayala factors in determining whether that person should get a bond. In order to help your attorney prepare for your bond hearing, You or your family members will have to get your attorney evidence to be able to show the court that you meet the Ayala factors and that you should be released. You will have to show the court that you're not at risk of flight. If you have family members or members of the community with a good reputation, they can come to court and speak on your behalf and show the court that you have sufficient ties to the community and that you will not flee if released. If you've lived in this area all of your life, you also want to bring that to the court's attention because it shows that you have sufficient ties to the community and you won't flee if released. In addition to stating that Young Thug was a danger to the community, prosecutors also argued that he was a flight risk. In fact, prosecutors actually quoted a song called Flight Risk, in which they claimed that Young Thug rapped. Got so much jury on right now, I'm flight risk. However, Young Thug's defense attorneys argued that argument should be disregarded because Young Thug was not even the person who wrote it, even though he was credited publicly for it. Unfortunately, Young Thug's defense attorney's arguments did not take flight because he was still denied bond. You will have to show the court that you're not a danger or a threat to the community. So if you've had a pristine and you've been an upstanding member of the community before this arrest, you want to point that out to the court. Now, while the allegations that you're charged with are not supposed to be brought up, the state will always bring up to the court how horrible the charges are. Your attorney will have to point out that the allegations are just that, allegations and not factors to be considered. You will have to show the court that you're not at risk of committing another crime if released. If you have no prior criminal history before this arrest, you want to point out to the court and show the court that because you have no prior history, it's unlikely that you will commit a crime if released. You would have to show the court that you're not at risk of intimidating witnesses. In this instance, I would usually point out to the court that we have no problem with there being a no contact provision with the witnesses. Also, if you don't know the witnesses and you have no way of even contacting the witnesses, I would want to point that out to the court as well. Now, if you meet all of these factors, you should be eligible to be granted a bond. But I will forewarn you, what I see all the time is that the more serious the crime is, the court will usually use the danger to the community factor as a reason to deny your bond. Did you know that prosecutors are claiming that witnesses are being threatened by Young Thug even while he's been in jail? The Atlanta Journal-Constitution reported that at least one person who was planning to testify against Young Thug is currently in protective custody due to his name being leaked online. Prosecutors in this case feel that this places a grave danger to witnesses, and they claim that there have been threats made that warrant witnesses being in protective custody. Defense attorneys, however, are asking prosecutors to provide proof. Kristen Nove, one of the attorneys representing Young Thug's co-defendant, Sergio Kitchens, also known as Gunner, states, "We want to know what specific threats there are. There have been many allegations that there are threats to witnesses, and to date we have received no discovery, not a single shred of evidence from a witness who was actually threatened." What are the types of bond that you can receive? Your own recognizance, sometimes called an OR bond or a signature bond. With this type of bond, the judge will take you at your word, using your signature as a guarantee that you will show up to court. You will usually see this with less serious crimes and with individuals who have little to no criminal history. You don't pay anything, you just sign the bond paperwork and you show back up to court when required. Cash bond. If you get a cash bond, you must pay the whole amount in full. For example, if the judge sets your bond at $10,000 cash, you must pay the full $10,000 plus fees in order to be released. The benefit of a cash bond is as long as you show up for all of your court dates, you'll get your money back. Property bond. Property bond is when you or a family member put up property that you own to get out on bond. You must typically present a deed and proof of the property's market value in order for the court to accept a property bond. However, before you put up your house for someone's bond, make sure that you are certain that that person will show up to court. I have seen one too many grandmothers lose their home because people fail to show up to court. bonding company. If you don't have the money to post a cash bond, you can typically use a bonding company if allowed by the court. Most bonding companies will typically charge a 12 to 15% fee of your total bond for you to bond out of jail. However, unlike cash bond, this money is non-refundable. Oftentimes, if you're granted a bond, the court will typically put bond conditions as a part of your bond. Some of these conditions could include having no contact with the witnesses or alleged victim, staying away from the incident location, not allowed to have any weapons, and other conditions that the court may impose. If you violate any of these conditions, the court could revoke your bond and you could have to sit in jail until your case goes to trial. If you need assistance with bond, make sure you contact the Foster Law Firm for assistance. Make sure you click like and subscribe to keep up to date with all of our episodes. Also, you can follow us on all of our social media platforms at FosterLawGA.com. If you have any questions about today's episode or any questions in general, you can submit those questions to info@FosterLawGA.com. Thank you for watching. See you next time.